So an update on where we are in terms of the accounts rules. We're implemented on the 25th of November, and we thought that this is a good opportunity, since we've been going out and about following launch, whether that be with reports with firms, with others that are interested in how the accounts rules work about this since implementation, and we thought that we'd give you an update where we're working on, whether it be guidance or whether it's just a point of clarity in terms of what the rules are by the profession. It's always good just to sort of put everything into context in terms of who the rules are. When we look at the individual solicitors that we regulate, we've got just shy of 200 individual solicitors that we regulate, so that's a huge number. Just shy of 10,500 law firms that are regulated by us as well. And when you look at the ABS, I've got 875 ABSs in that mix. It's really important then to all firms are holding client money and are subject to the SRA Accounts Rules, and we've got 7,000, and I think it's just over 7,000 law firms at the last renewal that confirmed to us that they have received or are intending to hold or receive client money. So it's really important that firms that are holding client money are doing so in compliance with the SRA Accounts. Just to sort of recap in terms of where we are in the journey that the accounts rules have taken, this wasn't to the future consultation until later on, because we'd already started work by team. So just to sort of recap very, very quickly that, that we made some minor changes back in 2014, and we introduced exemptions for certain firms not to have to get a report. So that was firms that were in totality, so that's your sort of criminal defence firms, and we removed the requirement for firms to submit unqualified reports to us. Moving on, phase 2 was 2015. This is where I looked at the role that they play in helping firms but understand whether or not client money is at risk and whether or not any breaches have happened in the firm, and what firms have done to remedy that situation as well. It was about moving them using their professional judgment rather than the tick box exercise or checklist approach that was there before. So this is someone that's going in that knows the firm, knows how they're working, knows the area of work that they're involved in, and the amount of client money that's being held as well. So the checks that they need to do should be proportionate and balanced in accordance with that firm and what they're doing. So that was really, really important. It was a really quite, should we say, prominent change in how the accounts rules worked and how they were, should we say, audited from a third-party perspective, and we extended the obligation in terms of the exemption to get an accountant's report. So we introduced a threshold that if you didn't hold any more than X amount in the accounting period, then you didn't need to get a report. And then phase 3, this is where it got the accounts rules review got brought into the Look Into the Future program that the SRA had, and it was looking at making sure that the rules were principles based. So it was removing prescription. What we wanted to do was firms' duty around safeguarding client money, but also then providing a simple structure to how the accounts rules were read. They've been at the SRA now, this is, I think year 16, and I've seen different read them. You would see something that was either added in or something was updated, and that they're extensive and sometimes difficult to follow because there wasn't that interaction between, say, Rule 2 and Rule 17, and these are that I'm throwing out, that that there was sometimes just some inconsistency in terms of how the rules were being read and the guidance that was being provided within those rules. So we wanted to introduce a simpler structure so it made it easier for not just existing firms but for new end of the market to understand what their obligations were and what is client money. So we consulted on something which would mean that, for instance, money, fees and disbursements could go straight into the business account. We heard a lot in terms of consultants that wouldn't work. It would have huge impacts in terms of things like VAT, systems and controls. So we've moved away from that and with a clearer definition, but also introduced something that helps, which is the exemption for firms that they hold is for fees and the disbursements that they're responsible for. Then they can hold that money straight into their business account. Moving on to the next slide, just sort of in terms of the obligation on firms, where does it sit? Some people have said that, just under the accounts rules don't set out very clearly that I as an individual in the firm an employee, the culp or the firm's coffer, or even the firm that we know in terms of safeguarding client money. That's because the safeguarding obligation sits within the SRA Code of Conduct. It's a standard. It's something that we expect of firms, and it's about safeguarding client money, making sure that money that's been entrusted is protected. How you do that is up to you as a firm, and this is where the new accounts rules have provided firms with that opportunity to look at what they need to do and think about who's involved in authorising withdrawing, about who's responsible for drawing up the reconciliations, who's responsible for implementing systems and controls around cyber. I think it should be you as a firm to develop your own processes and systems. So the account, and this is what we'll do now, is look at some of the things that we're hearing from firms or what we've seen. It says that, okay, what are law firms actually doing? So like I said, they're reviewing their systems and controls. I think a lot of that prescriptive nature that was in the accounts rules, so it was thinking about, okay, if I receive client money into the business account, I've got 48 hours for it to be moved. If I've got office money sitting in the client account after I've delivered a bill, I've got 14 days within which to move it. So a lot of that prescription was, you think, okay, is it in the client's interest, prescriptive nature? Is it, that one size fits all? Is it right? And that's where firms can review their own systems and controls and think, okay, what works for me as a firm, but also what do I need to do to make sure that I'm acting in my client's best interests, properly safeguarded. So a lot of law firms are now thinking about, okay, systems and controls, who's doing when, how are things happening, and different teams as well within firms as well are now developing their own bespoke systems. So the conveyancing team might have a completely different process to the family team or the criminal defence team. So it's making sure that the process that's got actually reflects the work that's been done. I think more importantly now as well is that law firms are developing their own systems or timeframes in terms of how quickly money is moved. And said that that client protection is really, really important here. That if I was a client, my money immediately, or it needed to be protected because it sits in a law firm's client account, then law firms shouldn't really be waiting 48 hours for it to be moved into the right account, or using that 48 hours that used to be in the old accounts rules as a should we say buffer, or sort of say, okay, we have got 48 hours because the rules say so. You might be dealing with that, okay, money's been received into the business account and needs to be moved to the client account for X, Y, and Z. Law firms should be managing their systems and controls so that that sort of payment is notified or identified immediately and then moved promptly into the right account. And I think when we're looking at the flip side, which is that office money sitting in the client account, that's for you as a firm to think about money sitting in your business account. You can't make any drawings on it. You need to pay staff wages. You need to be thinking about other expenses. But once the bill's been delivered, it's about you. And like I said, that with the definition of client money, what we had following the consultation and through the implementation of the new rules is that we've got that law firms can take advantage of the exemption, which is that they don't need to operate a client account if they only receive money for their fees or disbursements. And this is now started to see a lot of law firms think about how they're operating and the amount of money that they actually hold, and think about alternative arrangements as well, and we'll come on to some of those later on. But it seems that law firms are now slowly moving to thinking about, okay, do we really need to hold client money, which is the transactional side of things? And if we are only receiving money for our fees and disbursements, can we do away with the client account completely? What else are we hearing? Moving on to the next slide, you'll see we're also seeing law firms are moving money onto clients promptly when there is no need to hold. Something that got introduced and was already there in the old accounts rules as well was that you need to account to your clients promptly or immediately for money that you don't need to hold anymore. There's no reason for a law firm to hold client money once the matter's come to an end, or that damages have been received for the client from an insurer in a personal injury case. That money should really just go to the client immediately, or as soon as everything's been sorted in terms of any disbursements or any costs that might be due. And I think this is really important because when you're looking at the next point, which is that, it links into residual balances, the longer firms hold on to money, that there's a greater risk of clients losing contact with the firm, with fee earners moving the matter on to somebody else within the firm, and we slowly start to see firms increasing residual balances that they're holding, but also it's the amount of money that's being held in those balances as well. So it should be that firms should be looking at their systems and controls to make sure that their systems flag that, okay, we've now received money, and what do we need to do to make sure that it's accounted to the client as soon as possible. Another thing that we are seeing, and I think it's become more prominent now in terms of the different working arrangements that we have because of COVID-19, is that firms and staff are really looking at how they can share updates, but also share information and knowledge within teams. We're all working remotely at this point in time, and someone that's a fee earner that's not normally used to involved with the movement of money might now have to think about, okay, what do I need to do, because I haven't got access straight away just to walk down the bottom of the office to, whether it be my cashier, whether it be the coffer. So I need to think very, very carefully. So after the 25th, there was a sort of culture change within firms about sharing knowledge, sharing updates, thinking about that, the accounts rules apply to not just the firm, but all staff, all employees. So it's important that everybody understands the obligations that are on individuals in the firm, but also the framework within which client money needs to be managed. And I talked about alternatives, and when we look at the next slide here, that that a lot of law firms are now thinking about the interesting, because we're seeing new risks come about as a result of COVID-19 as well. I saw in the news just the other day that cyber attacks or fraud or scams are on the increase. We're all susceptible to all of these sort of scams, but I think as a law firm, these attackers, the predators, they know that law firms hold vast amounts of client money. So it's really important that we think about the systems and controls, and the protections that we've got in place to make sure that client money is protected. But what we are now hearing as well, though, is that law firms are thinking about alternatives. So they're not having that exposure themselves as a law firm. They're thinking about a TPMA as an alternative solution. So they're doing away with the whole concept of a client account. They're saying that that we can have all money go through a TPMA as and when, or they're using it as an alongside, so they'll still receive money for their fees and disbursements whilst relying on the exemption, and then using the TPMA for the transactional money that they might otherwise have received. Or what I've seen recently, which is really, really quite interesting, is that some law firms are doing the mix and match approach. So they'll still hold client money, which means that they might fall within the exemption to get an accountant's report. But for high value transactions, or even where there's an element of certainty in terms of, we know that this money's coming in, and we know that it's going to be paid out on such a date, and we know that it's going to go to X, Y, and Z persons, they'll use a TPMA alongside the traditional client account. So it's interesting to see how law firms are taking up the opportunity to think about TPMAs and start coming onto the market, so we can see these products really, really start helping firms manage the risks around operating a client account. So what are we hearing? And I think this is some of the, when we sort of launched this webinar, that, it was about your questions answered, and it was taking into account that we are working in slightly different circumstances, with offices being closed and everything else. We saw very early on, in terms of what we were hearing from firms, was that they can't comply with Rule 10. Which is the requirements around, or the requirement accounts for if you're operating Jatinder Loyal's personal Barclays bank account, because you've been appointed as deputy or you're relying on a power of attorney. That what we've heard is that firms are finding it difficult to come to help firms is put out a position which is that, if you can't comply with Rule 10 as drafted, then there is a minimum that we expect of you. So that's to keep a central register of all the accounts that you do operate. So it's Jatinder Loyal and Mr. Smith, Mr. Jones, and anybody else, and then keep a record of the transactions that you as a firm have instigated or are responsible for. But what we are looking at is the whether or not the Rule 10 as drafted should stay as it is, because I don't think we can have that holding position as a permanent feature. We really need to think about, okay, what is the risk that we're trying to manage here? And the risk is really quite sad when you think about, or when you see some of the stories where people that are appointed, whether it be as deputy or relying on a power of attorney, that the client sometimes doesn't even know what's happening in terms of how their money is being used, and they haven't got the capacity, and I'm not saying the mental capacity, they just haven't got the capacity to challenge the movement of money, because they don't need to. But we need to work with law firms, we need to work with reporting accountants and other people that are involved, for example, the OPG and, solicitors that are appointed as deputies, to think about, okay, what is it that we're trying to manage, and how do we make sure that the rules help manage that risk, but also that the rules are actually workable and can be complied with. Something that's coming through, and I think we've had quite a few queries come through on our ethics line as well, whether it be in writing or through web chat, is firms are not sure when they can take money for their firm's costs. So this is the play between Rule 2.1D that says that client money is money for the firm's fees, and any unpaid disbursements prior to the delivery of a bill. And like I said, the interplay or other written notification of costs incurred. So I think what we're seeing is that, okay, what do firms need to be doing? And I think we've always said from the very outset that the key requirement is making sure that client money that you hold or receive is kept safe, and you safeguard that money. I think where we've got firms that are looking to take money for anticipated fees, so for work that hasn't, we would probably question their approach in the sense that, okay, what is it that allows you to take money for work that hasn't yet been done, or for disbursements that haven't yet been paid for? That how can you make sure as a firm that the client's money is going to be kept safe? Because if that money goes into the business account, then there are risks around, say for instance, the retainer comes to an end, or the firm becomes insolvent, or the retainer comes to an end and the client decides to move their instructions elsewhere. So there are other risks that need to be thought about in terms of compliance with 4.3 of the rules. We are hearing a few questions, and we're getting more and more queries coming through. So we're looking at developing some guidance to help firms around this and setting out our expectations. I think a lot of firms, especially in the conveyancing industry, have asked questions around, okay, if we've had a direct debit set from our business account, need to do when it means that we want to take money from the client account to reimburse ourselves as a firm for those costs that we've incurred. So I think we're looking at all of these questions coming through, and we're going to be hopefully providing some guidance in the next couple of months in terms of where we are and what we're doing. We're also looking at the rules as well, that, is there something, as we're developing that guidance with reporting accountants and or firms, that, is there something that we need to do with the rules as well? So it's making sure that we have a set of rules that actually can be complied with and don't cause confusion. Because going back to the first slide that we had around providing clarity and reducing prescription was, the whole point was that we didn't add in confusion unnecessarily. So we're working through some of those issues, and hopefully, like I said, we'll have a position confirmed in the next couple of months. But I think for the moment, the position should be that law firms really need to think about, is it right to move money for anticipated fees or disbursements that haven't yet been paid for? And I think we're also hearing, what do we mean by on demand? In the rules it says that, that client money must be available on demand. And I always say that this is very much as was under the old rules, that, that if a client comes to you and says, okay, I want to terminate my retainer with you, you're holding money for me, can I have that money back? If it was a Friday afternoon, and it was, a large sum of money, we wouldn't expect the law firm to be releasing that money straight away. And I think firms really need to think about, okay, when will the SRA take enforcement action? So it's important to look at, okay, the whole picture and what's actually been set out before firms think, okay, are the SRA going to see this as a breach of the rules if we've delayed by 2 or 3 days in sorting something out for the client? If there's a valid reason for why there's been a delay, then the SRA are not going to take enforcement action. On the flip side, if there has been an unreasonable delay without any explanation as to why the clients had to wait X months or even years for their money to be returned to them, when we're talking about on demand, it's probably with a firm as well in terms of, okay, what's actually happened here and what's going on. What else are we hearing? In this slide, there's what we're just highlighting is that there has been a change in terms of what was the Rule 14.5 around banking facilities, and the new Rule 3.3, that there has been a change in words. We used to refer to an underlying transaction, whereas now the rules talk about regulated services or the delivery of regulated services, and I think the two are quite distinct. There is a key difference between the two terms. I think sometimes law firms were trying to stretch that they were involved in an underlying transaction. The actual work might have ended months and months ago, but because of that underlying transaction, they felt it was okay to hold client money and then operate their client account as a banking facility. So that it has to be in respect of the delivery of regulated services. So if no services are being delivered, then we would question why you're holding on to the client's money. There is no need for you to be exposed to such risks, and either should you be operating in such a way. If firms want to operate as a bank, then they need to be authorised and regulated by the FCA, the Financial Conduct Authority, for that sort of work. And I think what we've got as well now is we're coming up to 2 years with case studies. So we've started to review that now to make sure that it's still valid in terms of where we are, but also the case studies as well. Do we need to update those as well with some recent examples that we've seen either at the tribunal or even some examples that we've had come through to our professional ethics team as well. Worryingly as well, and I think this is some feedback that we've had from insurers, but also other people as well, is that some firms are not doing enough to prevent money being lost as a result of a cyber attack. And I mentioned before as well, I think we're working in very, very different, should we say, circumstances, networks and things like that, so that, should we say, the risk of an attack is much higher now. The risk of money being misused is much higher. We're seeing in the news every day that that cyber attacks are on the increase. So this is really important now, that if law firms are working remotely, that more is done to make sure that things like passwords are changed regularly, that only key people in the but also you're thinking about sort of what you need to be doing in terms of, is it necessary for you to still be holding clients' money if matters are on hold at the moment? That should you be coming up with thinking about alternative arrangements with your clients to say, okay, we'll return the money to you now, and then that if we're back up and running, or that things move on, we'll look at getting the money back for you, or even thinking about a TPMA, so that the you as a firm aren't exposed to that risk of being attacked through cyber. And I think another thing that we've heard recently is that some firms are thinking that they don't need to account for interest at all. The rules don't say that, which is again something that we made sure that the rules were quite clear about. Firms need to make sure that they're accounting to the clients where it's fair, and so you still need to make that assessment of how much interest has been earned on the client's money, and then you talk to the client and come up with different arrangements in terms of whether or not you can or should be accounting to clients for the money that's been received. And I think in terms of where we are and what we're doing, it's just a final reminder in terms of what we're expecting firms to be doing. We want firms to engage with us if they are having problems, but also thinking about putting things right as soon as breaches have been identified. This is where we're working with reporting accountants as well, because some firms are saying that it's become quite difficult now to provide our accountants with all the information that we would normally provide. Are there any workarounds, and will we be in breach if there's a delay in obtaining the accountant's report? Not sure whether people have seen, but we have published some Q&As in terms of COVID-19 and what it means, especially in respect to the accounts rules. So things around, if you can't bank checks promptly because of that you haven't got access to your bank, then what are the alternatives that are there? But also around the sort of the reporting accountant requirements as well. And if there is a delay, are there things that we can do to make sure that the accountants get information ASAP? So can we provide stuff to them electronically, having regard to client confidentiality and data protection issues, or is there any other way that we can give them access to information so that they can carry out their audit and make sure that there is no risk to client money? So there are some Q&As. Please have a look at them to have a look at what we've said in terms of reporting accountant requirements on you as a firm, but also for reporting accountants as well, that we've set out. We don't expect you to qualify a report if there has been a delay, and if that is the only issue that's been identified. If everything else is okay, we wouldn't expect you to qualify the report. It's still really important though that any should we say money that's been withheld from the client account or has been misappropriated or lost is replaced immediately into the client account. That that I think even where we are now, that law firms and solicitors are seen as a trusted and regulated profession. So there isn't any reason why law firms shouldn't be taking steps to make sure that money that's been withheld or lost is replaced immediately, because you are still acting for clients. And you need to talk renewal period that's just gone. There's about, I think, 2,000 firms that renew their insurance on the 1st of April, and we're coming up to the second most popular, I should say, what is the most popular renewal date for insurance, which is the 1st of October. Law firms really need to talk to their insurers and think about, okay, what are they doing to manage risk generally, but especially where there has been a breach of the SRA Accounts Rules. You need to talk to your insurers so that they can help you think about, okay, whether it be best practice guidance or whether it just be that they need to look at your profile as a firm now, and does that impact in terms of your premiums and any other arrangement that you have with your insurers. But more importantly, the insurers are there to, if there has been no dishonesty, then the insurers do need to step in, and they, under the SRA's minimum terms and conditions, they have to rectify any breach, or should we say replace any monies that have gone missing. And linked to that, then firms need to think about their duty to report to us. Yes, I'm working out of the office today, but I'm still here. The SRA is still working. The operational teams are still functioning. So it's important that you engage with us. If you need advice, talk to our professional ethics team. In terms of any situation that's popped up and you're not sure what to do next. But if you have identified something that's gone wrong and you think there has been a breach of the accounts rules or anything in the SRA standards and regulations, that you report those issues to us. It's important that we get information as soon as possible rather than later in the day. Otherwise, we will not be able to work with you and engage. So hopefully that this update's provided you with just a flavour of some of the issues that we've heard since launch. In terms of new guidance that's coming out, like I said, we are working on the Rule 10 issue. That is really quite important, but also the issue around, which we say, confusion around whether or not law firms can take money for anticipated fees and for disbursements that haven't yet been paid for, and I think it's really important that we work with law firms, reporting accountants, and others that are involved in the SRA Accounts Rules to make sure that we sort these issues out. So please keep following us as the SRA, whether it be on Twitter or engaged on LinkedIn. Follow me. connect with me on LinkedIn, because I'll post stuff on LinkedIn as soon as there are updates to the accounts rules or anything else that we're working on as well. I think you will have seen that we've tried to respond as quickly as we can in terms of questions around COVID-19 and what it means, not just on the accounts rules, but also questions around, okay, what if the firm's coffer is taken poorly, isn't there, what do firms need to do to get a replacement in place, but also providing clarity. I think the other week we updated our Q&As on something that's been instigated, or an initiative that's been instigated through government and the British Business Bank. It's about providing funding to innovative businesses with through an equity matching scheme. So yeah, we're trying to update our Q&A, and we'll carry on doing that whilst we're in this different and for some people unusual way of working. But hopefully we'll be back up and running, and we'll be back to our offices in some shape or form in the coming months. So yeah, so please keep in touch with us. Hopefully this update has just provided you with just a bit of insight in terms of some of the issues that we're seeing, and hopefully where we've been able to provide some clarity today, that's helped, but also just clarity and an expectation that we're working on something that will be coming to you in the next. So thank you for joining today. Like I said, keep in touch, and if you need anything, please get in touch with our professional ethics team immediately, because they are working through email and web chat as well. But yeah, like I said, keep in touch with us as the SRA, connect with me on LinkedIn, and you'll see updates as and when they're made. Wishing everyone a good afternoon, and hopefully see you soon. Take care. Bye now.